Hi, I'm Paul Powell, coming to you live from the studios at Husch Blackwell in Kansas City, which sometimes doubles as our conference room or storage room. Let me get it out of the way first. Go Chiefs! I'm sorry, I know some of you are not coming to us from the Kansas City area, but that was a big win last night, and we take our little victories where we can in these pandemic times. Welcome, and thank you for joining us. It's a little odd today. Normally we do these seminars live, and we like to do it that way. In the live presentations, when we're all together, this is the point where I normally try and take credit for the breakfast burritos and everything that our staff put together for the morning. It's a little different. Feel free, though, it's over the lunch hour. Feel free to grab a sandwich, some chips. I can't see you, so it's all just fine. Instead, I'm going to do a little housekeeping right now on the technical issues. First, if you have any technical difficulty today, go to the audience technical tips tab that's on your screen. That'll give you some good advice on common problems. If you still have problems, you can go to the help icon, which is the little question mark. Hopefully that'll take care of things. If you're using a mobile device, a phone or something else, first, God bless you. You're more confident in these things than I am. But in order to get your best experience out of that, it's best if you use Safari as your browser. And then two, turn it to landscape mode. You'll get your best results. Questions? We invite questions. We encourage questions from our audience members. Unlike at in person, we can't answer them live, or I can't answer them on the screen, but we've got some of our folks who are prepared to look at those from the chat boxes. You'll see there's a question box, a chat function, and our folks will answer them if they can live at the time. If we either have too many or we need to follow up on something, we'll get back with you in the minutes or hours or days after the presentation. But please feel free to ask any questions you have. If you want copies of the presentations, the slide decks, or bios of the presenters, those are available in the resource folder on your screen. And this program today has been approved for HR and legal credit. There are a couple of hoops we have to jump through on that, particularly if you want Kansas credit. Probably the most important thing, there's a survey, and I'll talk about it again at the end, that you have to fill out at the end of the program before you log off in order to get credit. And also, to get Kansas credit, we have to have 3 live poll questions. So we'll go to those. You'll be able to log in and give your answers, which will really fulfill 2 functions. 1, make sure everybody's awake and actually paying attention on these things. But 2, it'll allow us to benchmark some of what our clients and friends of the firm are doing at their companies. We've got 6 topical segments today, which will be about 15 or so very short presentations from a number of our attorneys. Most are from the Kansas City L&E legal team, working from their homes. Unlike me, I'm here, but most of our team will be presenting from their homes. We've got 2 from one from Milwaukee and one from our DC office that are helping us out today, and we'll go to them. Those are our foreign correspondents, if you will. So we've got a lot of ground to cover. In the words of the immortal Jerry Reed, we've got a long way to go and a short time to get there. And yes, I've done it. I've made a Smokey and the Bandit reference. You don't get that from a lot of firms, but we go the extra mile here. To kick things off, I'm going to first send it to Brian Zickafus and Ben McMillan, who are going to talk about some anticipated causes of action in Kansas and Missouri. Take it, Brian.
Thank you, Paul. Hello, everyone. My name is Brian Zickafus, and I'll be presenting with Ben McMillan for this portion, and we're going to be talking about legal updates. And in particular, we are going to talk about 2 legal updates. One is the Missouri Whistleblowers Protection Act and some recent case law, and religious issues in employment law. I'm going to be handling the Missouri Whistleblowers Protection Act, and we'll address that issue first. So back in 2017, Missouri Senate Bill 43 amended the Missouri Human Rights Act and created the Whistleblower Protection Act. Now, I think a lot of people have talked about the Missouri Human Rights Act, and there's been an awful lot written about it and a lot of case law, but I don't think we've had the same amount of attention paid to the Whistleblower Protection Act, which makes it unlawful for an employer to discharge a protected person because of that person's status as a protected person. And so now in Missouri, there are really only three ways to bring a retaliation or whistleblower claim. One is through the Whistleblower Protection Act, one is a retaliation claim under the Missouri Human Rights Act, and a third is a workers' compensation retaliation or discrimination claim under the workers' compensation statutes. There is no longer any sort of common law whistleblower claim in Missouri like there still is in Kansas. So it's got to be one of these three statutes or not at all. So how do we define a protected person under the Act? And there are three different ways. It's someone who has reported to proper authorities an unlawful act, reporting of serious misconduct that rises to the level of a violation of law, or a refusal to carry out a directive issued by an employer that, if completed, would be a violation of law. So three different ways, two reporting avenues, one opposition or refusal avenue. And some recent case law has made this even more narrow, I believe. Steak and Shake versus White in 2020 made clear that threatening to go to an external authority, whether it be law enforcement or some other regulatory agency, is not enough to become a protected person. It actually has to be a complaint. Ward versus G4, also a case decided in 2020, talks about whether or not an employee's off-the-clock illegality can form the basis for a complaint. And the answer to that question is no. It must be a misconduct or an act of misconduct by the employer, not an employee outside the context of employment. So they further just made some minor narrowing of the law there. One thing to also note is when you're talking about the Whistleblower Act versus the Missouri Human Rights Act, there's a distinction between the two in the context of retaliation. And that is generally with regard to the Missouri Human Rights Act, a complainant only needs a good faith belief that what they are saying is a violation of law, where the act suggests that it needs to actually be a violation of law, not just a reasonable belief that a violation has occurred. So that is an important distinction. Now, there's a couple of exceptions that exclude somebody from being a protected person. First of all, if it is somebody's job to raise issues of illegality or other concerns, then they are not a protected person under the Act. And the other exception is if the person that the complainant reports the alleged violation to is the alleged bad actor, then that is not a protected complaint either. The idea is you have to complain to somebody else other than the alleged bad actor. An interesting limitation to this portion of the Act occurred with Salerno versus MPI, another 2020 decision, where in that case, the alleged bad actor had not actually made the decision or acted illegally at the time of the complaint. And the court said that at that point, there was no protected activity because the person had not actually engaged in the bad act yet. So I thought that was an interesting limitation. So really at the outset, what does an employee have to show to have a claim under the Missouri Whistleblower Protection Act? First, that they're a protected person who engaged in a protected activity. They either have to report something or refuse to do something. They have to be terminated, and the refusal has to be the motivating factor for termination. So how does an employer protect itself against claims like these? First, have a policy for reporting alleged illegality and prohibiting retaliation for reporting. Very important that you have those. Generally, in a lot of the handbooks that I've seen, there are anti-retaliation provisions in the context of discrimination or Title VII claims, but not in the context of just illegality. Train your managers to receive reports. If they're going to receive these reports, just like Title VII or other discrimination complaints, they need to know how to act. Third, investigate and document. Why do you want to do this? Number one, it's the right thing to do. You don't want your employees engaging in any sort of illegality, but at the very least, to protect the company, what I have seen a lot of in these cases is someone will raise a concern that doesn't rise to the level of illegality, and it somehow morphs through various iterations of a lawsuit such that they now allege that they complained about illegality. And again, it has to rise to the level of illegality, and you want to lock them in to their complaints as early as you can. And before you terminate somebody, establish whether or not that person is a protected person under the law, and look at temporal proximity. The closer in time between the complaint and a termination, the worse it is for the employer. It looks more causally related. So when you're looking at terminating an employee that has recently made a complaint, tread very carefully and make sure you have a very, very solid, legitimate, non-retaliatory reason for termination. And now I'm going to pass it to Ben McMillan for some discussion on religion in the workplace.
Well, thank you, Brian. And I'd like to start by briefly introducing myself. My name is Ben McMillan. I'm a partner in the Kansas City office of Husch Blackwell. I work exclusively in the area of labor and employment. We're delighted to have each and every one of you here today, and we're grateful for the opportunity to share with you what we believe are some very important updates that have developed in the area of labor and employment law, both of which, or really several of which, at least for my presentation, have happened post-COVID, post-pandemic. So I believe, as Brian indicated, I'll be talking with you today about religion and the workplace, and specifically what we believe will be some potential tension or conflict between other statutorily created rights and also the rights that American employees enjoy regarding the free exercise of their religion. As a brief and very basic review, when we talk about religious liberty in the United States, we're really talking about three primary sources. The first is the most sacred and the one that we all know, and that's the First Amendment that protects citizens from government. The second is Title VII, and that's a statutory protection provided to employees to protect them from religious discrimination by their employers. The third, and one that we're going to talk about today, is the Religious Freedom Restoration Act, or RFRA, passed originally in 1993 and then again in 2000. That protects companies and individuals in some situations from being compelled to do something by an otherwise neutral statute that they believe violates an essential tenet of their religion. Now, the challenge for the Supreme Court and also for you now, employers, is to really navigate the statutory tension between these religious liberties and other statutorily created rights. It is easier said than done. I want to start by talking very briefly about the Bostock opinion that no doubt most of you have heard of. Came out on June 15th, 2020. The principal and indeed very specific issue before the court was whether Title VII prohibits discrimination because of sexual orientation or gender identity. That was a 6-3 holding in which the court, specifically Justice Gorsuch, held that Title VII did indeed prohibit discrimination based on sexual orientation or gender identity, as that is necessarily discrimination based on sex. The significance of that is somewhat obvious. It now means that LGBTQ employees can bring a cause of action under Title VII to enforce the non-discrimination provisions thereof in the workplace. And if you're looking at my slide now, you'll see a little preview as to what I'm going to talk about in a couple minutes. There will be employers claiming religious exceptions to this under RFRA. And we also think there's going to be potentially some problems in the workplace with employees that cite their religious belief or beliefs in either resisting or indeed refusing to comply with or be cooperative with this new reading of Title VII. Certainly, we all need to review our policies and procedures regarding complaints of discrimination, prohibited practices, but also things like locker room and bathroom usage. We all would encourage you to do that sooner rather than later. The second case I want to talk to you about is Lady of Guadalupe School versus Morrissey Borough. And we believe these two cases are going to intersect at some point. This was decided on July the 8th, 2020. The issue there was whether the First Amendment, specifically the free exercise clause, prevents civil courts from hearing causes of action under Title VII brought by employees of religious institutions. And religious institutions is broad. It's most basically like a church or a synagogue or a mosque, but it also can be educational institutions, which was the issue here. In this case, two elementary school teachers at Catholic schools brought claims of discrimination under Title VII and the ADA. The school argued in response that these two individuals were essentially ministers or part of the ministerial exception to Title VII. The court held 7-2 that they agreed with that argument, applying this ministerial exception to teachers because they were responsible for instructing students within their faith. Now, the more significant component of that opinion was that not only did it expand the scope or the category of employees who would be considered exempt from bringing claims under Title VII because of this ministerial exception, it also provided some pretty serious and significant deference to the institutions themselves to determine which employees they contend serve vital religious functions or have vital religious responsibilities within their organization and are therefore exempt from bringing claims under the statute. So two significant opinions there, both of which we believe will intersect at some point. Now, I want to talk briefly with you about the potential conflicts that have been identified here between these emerging areas of law. There could be conflict between employers and employees. There are going to be some employers that claim that compliance with the Bostock opinion violates a religious tenet that to which they subscribe. And indeed, Justice Gorsuch in the opinion acknowledged this and said RFRA operates as a kind of super statute. And by RFRA, we mean the Religious Freedom Restoration Act, and it might supersede Title VII's commands in appropriate cases. The justice also stated very clearly that religious liberties will arise under this opinion, and that there will be a need for other cases to make their way up to the Supreme Court to have these more nuanced and specific issues adjudicated and fleshed out. We also anticipate that there could be conflict between coworkers, and we hope there won't be much, but we anticipate there could be a scenario where perhaps there's an employee who is transitioning from one gender to the other, might meet some resistance from a coworker, for example, at using their now preferred pronouns or calling them by a different name. And that employee might resist doing so based on a religious belief. Our advice on that is pretty similar to the advice that we give on most employee conflict. Number one is to follow your company policies and procedures in addressing that conflict. And again, we urge you to take a look again at what those policies and procedures say in light of the Bostock opinion. Consider ways to accommodate religious-based concerns. That might mean having that employee work in a different area of the office or some other way to avoid this conflict. Ultimately, employees should be required to act professionally and respectfully toward coworkers. The difficulty here is you're looking at an individual who may now have a claim under Bostock for discrimination or harassment based on a sexual orientation or gender identity, but you might also be looking at an employee who may have a claim under Title VII for religious discrimination if they are disciplined or terminated because of what they perceive to be resistance to doing something that they think violates their religious principles in the workplace. So we think this will be nuanced. There will be conflicts and challenges presented, but with thoughtful approach, we think all of you can navigate through this, and we will be sure to do our best to keep you abreast of all subsequent developments. I believe that's all the time I have. Thank you very much for listening. I hope it was informative. I'm going to turn it back over to Paul.
Thanks, Ben. That brings us to our first poll question of the day. get your clickers, your mouses ready. You can see you can answer on the screen and then submit. Does your company have a written whistleblower policy rather than just a discrimination-related retaliation policy? And you can answer either yes, no, or I don't know. Click on it and submit, and we'll tell you the results in just a moment. All right. Well, kind of interesting. Looks like 51% said yes, they have a written whistleblower policy. 33% no, and about 15% said I don't know. Interesting. Thank you again for participating in that. That gives us some good benchmarking. So moving on to the second segment of our presentations today, that brings us to the work from home issues and the new reality. I'm in the studio right now, but 99% of the time I'm at my home office. And if we were there, if you've been on Skype with me or anything else, you know that if I was sitting there, I'd have my construction paper heart on the wall behind me. And I might have the dog scratching at the door, or maybe my neighbor decides to mow his yard. And maybe you'll get to experience some of that with our other presenters today. I hope not, but maybe, who knows? But working from home, for the most part, it works. It works better than many of us thought it might. It works better. It's been more productive than I thought it might be. And if it is the new reality, then we have to be ready for that and the peculiar employment law situations that may arise. We're going to talk about three issues today related to work from home. The first, and I'll be talking about that, is timekeeping for hourly employees. The second, Kat Pearlstone will be talking about work from home reasonable accommodation requests. And the third, Rachel Scott will be talking about payroll tax considerations. So I'm going to start out on the timekeeping. This has become such an issue in the work from home that the Department of Labor Wage and Hour Division issued its Field Assistance Bulletin in late August of 2020. Now, it talks specifically about timekeeping for work from home workers. And there's nothing drastically new. There's nothing really new in the Field Assistance Bulletin, but nevertheless, it reiterates the issues, and it's a good reminder of the obligations. The first and probably the most important is that it's the employer's obligation. It is always the employer's obligation to accurately record the time that employees work and to pay for that time. As employers, we can't slough that off and put that obligation on our employees. We can require them to report their time, but the obligation ultimately rests with us as employers. Now, to do that, many employers use tracking software of some kind. That's not required, but it is permitted. It's perfectly okay. Literally, all that's actually required is some form of record keeping. And you can get that information from your employees either through emails or they can call their time in. There's no specific way. We just have to keep records of the time worked on a particular day and in the particular work week and work period. Now, and of course, to pay, the obligation is to pay for all that time actually worked. Some of the trips and traps. Beware of work that's outside the normal business hours in the work from home setting. And that can be a number of different forms. It can be for the employer's convenience, that they didn't get to what they wanted to do that day, and so they're working on a report in the evening as they watch television. Or it could be that they're receiving calls after hours, or they stay logged on and they respond to emails that come in after hours. Whatever it may be, the after-hour work that's done outside of business hours, if it's legitimate work for the benefit of the employer, it's compensable time, has to be tracked, and it has to be paid for. Now, there's one other, an interesting additional twist on that, a new twist, just because you don't have anything else that's been a new twist in the last 6 months. But a new twist for work from home employees is paying those employees for commuting time. And what I mean is this. Normally, as you know, employees who come into the office don't have to be paid for their commuting time, even if they may live a half an hour away. So a half an hour each way, you don't normally have to pay for that time. The Portal to Portal Act is a specific amendment to the Fair Labor Standards Act, and it says that you don't have to pay employees for commuting to and from their regular workspace. But, and here's the twist, if it becomes that the employee's regular workspace is their home, they're working from home now, either as part of an extended pandemic or the next pandemic, or because for overhead purposes, or because it's popular with employees, you have more employees working from home in the future. If the home becomes the regular workspace, then a good argument can be made that anytime they're required to come into the office for special meetings, to get supplies, for whatever reason, that can be compensable work time. And that's going to be a significant difference, and one that would be pretty easy to trip over. To be honest, I don't think there's been any opinions out there yet, but in our estimation, it's at least a legitimate argument that could be made. If the regular workspace is no longer the office, it's work from home, then requiring employees to come into the office for legitimate work reasons can be compensable time. So keep that in mind. What's this all mean for us? It's probably a good time to update our policies on timekeeping. Maybe you've got it all covered, but at the very least, it's a good time to look at it. Update the policies to document expectations. First, we want to encourage employees to record all their time and reiterate that the employer wants them to record their time and wants to pay for all hours worked. Second, it is absolutely appropriate to lay out our expectations about timekeeping, not only how timekeeping will be captured, what kind of records will be kept, but our expectations as employers about when employees may be working outside normal business hours, whether it's appropriate to be answering emails, taking phone calls, working on reports, things like that, whether and under what circumstances they may be paid for commuting time. And it may be that you want your employees to be answering emails after hours, but we have to recognize we have to pay for that. And it's perfectly appropriate to require employees to get advance approval to work outside of normal business hours or to be working overtime hours in a particular pay period. If they do it, we have to pay for it, but it's perfectly appropriate to put limits on that and to require the expectations. And so hopefully those will help minimize any issues in timekeeping. So next, I want to turn it over to Kat Pearlstone. Kat's going to talk to you about working from home as a reasonable accommodation. Kat, take it away.
Thanks, Paul. Hi, everyone. My name is Kat Pearlstone, and I am going to be covering how to handle accommodation requests in the work from home and hopefully return to work era. A lot of employers right now are either in the phase of transitioning back to in-person work or are planning to do so in early 2021, knock on wood. And while for a lot of us it feels like we've been in this pandemic mode for years, it really has actually been a few months. And along those lines, a lot of employees still have a lot of fear and anxiety about COVID and potential transmission and exposure because there's a lot that's still unknown. And as a result of these concerns, when you're transitioning back to in-person work, we expect that there will be a higher than normal amount of requests from employees seeking to continue to work from home as a reasonable accommodation for a various number of ailments. And when you're getting these requests, we've kind of identified 3 core conditions that we think that are going to pop up. The first is going to be mental health related ailments. These are going to be stress and anxiety related disorders or depression. The second is going to be people that are currently seeking medical treatment where the treatment suppresses the immune system. So people who are getting cancer treatments, for example. And the third is conditions that in and of themselves cause a compromised immune system. And this is going to be things like, for example, autoimmune disorders. When you're evaluating these accommodation requests, there's kind of a three-prong analysis that needs to be met for an accommodation for the law to require an accommodation to be granted. The first is there has to be an employee that has a disability. And the threshold for what constitutes as a disability has progressively been getting lower. And that is especially true in the pandemic era. The second is that the employee that must actually need, not want, but need an accommodation to perform the essential functions of their job. And alternatively, they must be able to perform the essential functions of their job if they are granted the requested accommodation. The third is that the accommodation must be reasonable. And when evaluating the reasonableness of an accommodation, in years past, employers have really pushed back on the concept that remote work is reasonable. Arguments, against the idea that was an accommodation employers had to grant included that employees weren't as productive at home, that you can't effectively manage their work, and that employees who are in supervisory positions and have subordinates can't effectively manage their personnel from a remote position. Things are going to be a little different in the COVID-19 area. We anticipate that it's going to be a lot harder to argue that remote work is not a reasonable accommodation. And this is especially true for entities that transition to partial or full remote work in the beginning of the year or are still currently offering partial or full remote work. That being said, it doesn't mean that every single employee that requests to work from home automatically gets to do so. Employees that have jobs that cannot be completed from home, obviously this would not be a reasonable accommodation for them. And this is going to include positions like truck drivers or people who janitorial services, anything where you have to actually be on site to complete the work. We expect to see a lot of these requests in office employees where there's a little bit more flexibility, but even in that instance, remote work is not the default accommodation. And it's important to remember that while you're entitled to engage in the dialogue and potentially offer a reasonable accommodation, the law does not require you to offer the employee their preferred or necessarily requested accommodation. So when you're dealing with accommodation requesters, we have kind of a three-step strategy. The first is a proactive step, which you should do in anticipation of getting these requests, which is to review the job descriptions of your employees and make sure that the essential functions are clearly outlined so that you have documentation to point to summarizing what it is that can or can't be done based on the accommodation requested. The second is once an employee has made an accommodation request, you want to engage in the interactive dialogue. And this is the chance to really talk to the employee about their condition, what their concerns are, and what it is that is preventing them from completing their work without an accommodation. And you want to really take your time here. And if you can, document the meetings you have with the employee. So you have something to show how many times you met, what you talked about. And the reason is because even if you don't reach an agreement and you can't decide or agree on an accommodation and let's say subsequent litigation ensues, the EEOC is really going to focus on this stage and look into whether or not you made a good faith effort to work with this employee. So it's a really good chance to kind of proactively create some positive documentation for yourself on the off chance a resolution isn't reached. The third option or the third step is once you've confirmed the job descriptions are good to go, you've engaged in the interactive dialogue, it's up to the employer to then evaluate options and decide, is there a reasonable accommodation we can offer? And if so, what is it? And when you're evaluating options, especially when the requested accommodation has been reworked, you want to consider if there are alternative accommodations that could also satisfy the employee's needs. An example would be a leave of absence, either unpaid under the FMLA, if that's applicable, or potentially under any kind of leave of absence policy that's been implemented. This is also where the Family First Coronavirus Response Act may come into play, depending on the underlying reason for the accommodation request. You could also look into erecting physical barriers for employees in open office spaces or changing the office layout so that they feel more protected. This would include if you have an employee that doesn't have necessarily an office, offering them an office with a closed door to work in temporarily. Another option to consider is offering personal protective equipment. This is going to include gloves, hand sanitizer, masks, things like that once they return in person, or making changes to the work schedule, such as doing a rolling work schedule, having people come every other day, or having staggered start times so not everyone's going in the elevators or being in the building at the exact same time. And that just helps to reduce the amount of contact between employees. But the most important thing to remember when evaluating these accommodation requests is that it's really going to be a case-by-case analysis that depends on the employee's job description, what it is the underlying condition is, and what it is they're seeking. Now, Rachel is going to talk about tax issues and other considerations.
Thanks, Kat. Hi, I'm Rachel Scott, and I will be going through some of the tax issues and considerations that employers will want to look at given the remote working situation and some certain COVID exceptions. The three general issues that we're going to briefly discuss are payroll tax withholding and reporting, income tax issues, and sales tax issues. The first is payroll tax withholding. Generally, and we're specifically talking about income tax withholding for employees. And so that's typically based on where the employee performs services. So if they're in Wisconsin, typically Wisconsin income tax should be withheld. And if they're performing services in Missouri, typically Missouri income tax should be withheld. And so this presents a specific issue, especially for employers who have headquarters near state lines. You'll typically see this with Kansas and Missouri. But the issue is that if the remote worker is not a true temporary worker and they're working from their home or from a new state for more than couple days time period, the employer should likely look into withholding income tax for that state. Now, there's likely low risk of noncompliance if, say, the employee is there for 1 or 2 days. Often even attorneys will travel for a couple days, and employers won't necessarily withhold for different states. So there's low risk for that type of noncompliance. But with COVID, we're seeing a lot of people work from home for a few months or maybe permanently working from home. And so that's going to trigger some compliance issues. A lot of states have given guidance about certain COVID exceptions or specific circumstances where they wouldn't impose their income tax on an employee working remote because of COVID. But of course, that's state specific. So wherever you have employees, they're going to want to look and see, whether that state has given any guidance. And if not, then the safe route would be to look into that state's withholding. The next issue employers would want to look for is creating income tax nexus. The concept of nexus has to do with the employer having some type of presence in a state, which often will create an income tax filing and payment obligation. And of course, every state has a different view on whether employees will create nexus themselves without, any other activity. Some states look to what type of services the employee performs and consider that as to whether that employee will create nexus, or the state might look at how many employees the employer has in a state. And so each state approaches it differently. And so it's important for employers to know where the employees are located and look for possible income tax nexus, because that will create an apportionment obligation for the employer, and they may need to submit income tax filings and payments. And of course, some states have said that they won't impose income tax on employers who have employees in their state because of COVID. But of course, those exceptions are usually contingent on the number of days that the employee is in the state, or they're only for a specific time period. So after 2020, the state will impose nexus on the employer. So they're limited in time for the employee, but also time in terms of the calendar year. And then the same issue is there for sales tax, nexus for sales tax. Typically we see taxpayers triggering sales tax nexus based on economic nexus, which is determined based on the number of transactions and or the amount of sales that a retailer has into a state. But of course, if you have an employee in the state, the employer will want to assess if they are now subject to sales tax in that state. And then the last thing is international taxes, a bit similar to income tax withholding, but if you have an employee working out of the US, the employer will want to look at where that employee is and if they have any obligations there, and whether they have any obligations in the state in the US that the employee usually works in. Though, of course, there have been COVID exceptions, but those are very specific and sometimes narrow. So employers will always want to look at those specifically for the relevant taxing jurisdictions. And then just a summary, employees working from home creates probably more tax issues than most people realize. So it's important to connect with your accountant or your attorney and let them know where you now have employees, because if you haven't had any activities in those states before, it's likely that you're not realizing the potential tax implications that might have. And so we recommend talking with your accountant, your attorney, and just disclosing where you now have people and seeing if that might be an issue for you.
Thank you, Rachel. Rachel joined us from our Milwaukee office today, so wanted to thank her for helping out and pitching in on that. Very helpful, very interesting. So now we've talked about the new reality of many employees working from home, but either already in the last 6 months or soon, being optimistic, employees are going to start heading back in to the workplace. And what do we do there? Minimizing liability when it's time to have our employees start coming back into the workplace. For this segment, Julianne Story is heading up our team. And Julianne, you're on.
Thanks, Paul. Hello, I'm Julianne Story, a partner in the Kansas City Labor and Employment Group, and I'm coming to you from my home office in Fairway, Kansas. My colleagues, Jenna Brofsky, Brian Hendricks, and Courtney Stillman and I are going to talk to you this morning about issues to think about and ways to minimize risk as you return to work or the office. Our presentation will be in 2 parts. First, Jenna and I will talk about the impact of COVID on caregivers and other vulnerable employees. Then, Brian and Courtney will discuss OSHA and other safety considerations, including testing and waiver. So let's jump in. COVID-19 has impacted all of us in one way or another, but some people in the workplace have been affected more. The FFCRA, which expanded protections for employees, was based on the formal acknowledgement by Congress that caretaking responsibilities are an important part of the lives of Americans and they critically impact people's ability to work. In addition, the CDC has identified people who are vulnerable, older workers, and people with certain health conditions. We have identified 4 categories of employees for our presentation today because they have experienced the greatest impact and they pose the greatest risk of liability. Those categories are older employees and those with disabilities, parents and caregivers, and pregnant employees. Because Kat Pearlstone spoke about accommodations of employees with disabilities earlier, we'll spend more time in our presentation on the other groups. At the end, we'll leave you with some best practices to minimize risk. So let's jump in. The first category are older employees, and this group presents a real challenge for employers. The Age Discrimination in Employment Act and state counterpart laws prohibit discrimination in the workplace against people who are age 40 and older. But the CDC and many local governments have said that people age 65 and older are high risk for greater and more serious illness as a result of COVID. This might cause a reasonable employer to tell older employers to stay home. But the EEOC has said you cannot bar older people from the office. In June 2020, the EEOC issued guidance saying that an employer cannot involuntarily exclude older people from the workplace based on age, even if excluding them is for benevolent reasons, such as protecting them from COVID. The EEOC also said that it is acceptable to provide flexibility for older workers, those age 65 and older, even if older workers result in being treated more favorably compared to younger workers still in the protected age group. But what is more favorable treatment? Is it continued work from home? What if the older employee then becomes marginalized from the rest of the group, which has returned to the office? You can see the dilemma. Importantly, the ADEA does not have an accommodation requirement. In other words, there is no legal requirement under the age discrimination laws to accommodate an employee based solely on age. As with any employee, however, regardless of age, accommodation under the ADA may be required for a disability. The bottom line is that flexibility is key. However, it's that concept of flexibility that leads to the next concern, disparate impact claims. A disparate impact theory of liability is based on the notion that a neutral policy or practice negatively impacts a particular group. So keep in mind that accommodations provided to one category of employees could have a disparate impact on others. For example, who gets to telework? There's a potential adverse impact based on age if only parents with young children are granted the accommodation of work from home. So consider whether telework is available to an employee with any caregiving responsibilities, not just parents with children. We often get the question about whether providing accommodation for one employee creates a precedent for others. While the EEOC has said that accommodation under the ADA is all about individualized analysis, particularly in the COVID environment, when granting an accommodation like telework for caregivers, you may very well have difficulty denying the same accommodation to a disabled employee in a similar position based on unreasonableness or undue hardship. Now I'm going to turn it over to Jenna.
Thank you, Julianne. So I'm here to talk about employer responsibility and minimizing risk when it comes to those employees who have children or caretaking functions. I want to quickly start by talking about the Families First Coronavirus Response Act, the FFCRA, noting that it only applies to employers with under 500 employees, and there are additional limitations on businesses within the healthcare industry. In fact, the DOL has updated its guidance onto who falls within the exemption. So be sure to check the DOL website or your counsel, like me, for updates. So this is the law. It's in effect until December 31st, 2020, the end of this year. And to Julianne's point, it recognizes the impact that caretaking functions can have on an employee's ability to do their work, particularly during a pandemic. And the two provisions that are directly on point are the provision that provides leave to care for someone who's been advised to quarantine, and the provision that provides leave to care for a child whose school or place of care is closed. Now, in terms of potential liability, like the Family and Medical Leave Act, the FMLA, and other leave laws, there's a provision prohibiting discrimination, retaliation, and interference with rights under this law. One technical note, an employee can only bring a lawsuit under this provision against an employer if that employer was already covered by the FMLA. So for those smaller employers with under 50 employees, who, this is the first time maybe that you're having to provide this type of leave, the threat of a lawsuit under this provision is not as great. However, the DOL does have enforcement authority under this provision, so there could be other consequences, and numerous states and municipalities have their own COVID-19 leave laws, and they might have overlapping reasons that are covered under those laws. But back to the FFCRA. So we've actually already seen a whole bunch of cases alleging both interference with rights and retaliation. And from what I can gather, it's usually a situation where somebody asks for leave and then a decision was made at the same time that they should be terminated, but communicated to them after they already requested the leave. So the practice of documenting your decision-making, why and when, that the HR folks on this call are already very comfortable doing can really make a difference in responding to a claim of FFCRA discrimination. On to the next. So what should employers be thinking about outside of mandatory leave? On a very high level, employment decisions cannot be made based on protected categories. And those categories are determined by the specific laws that apply, like Title VII, and in Missouri, the Missouri Human Rights Act, and in Kansas, the Kansas Act Against Discrimination. Now, none of those anti-discrimination laws has a category called caregiver status, but employees cannot be treated differently based on sex. Sex is a protected category in those laws and in almost every anti-discrimination statute in the US, which means no sex stereotyping. And recently, the United States Supreme Court decision, Bostick, that you heard about earlier, touched on the prohibition against sex stereotyping. In that case, sex stereotyping related to who somebody was attracted to or married to and or what their gender was. We can analogize to our topic here, which is about caregivers. The term caregiver bias is based on this belief that women are primary caregivers, and as a result, they will be distracted from work by caregiving responsibilities. And it may very well be true that women handle the majority of caregiving. But the issue is when we use that to say, well, women probably won't want to travel to this really interesting convention because they have to be home with their kids. Or in COVID-19 times, women should probably stay at home and work remotely to be there with the kids, and the men should come into the office. Employers should never be using assumptions about someone based on their sex to make employment decisions. And we've already seen FFCRA claims brought by both women and men, so this isn't a theoretical discussion. And sex stereotyping isn't something new. Since 1972, Kansas has had a regulation which states, quote, an employer's rule which forbids or restricts the employment of married women and which is not applicable to married men is a discrimination based on sex prohibited by the act. This rule also applies to unmarried women who happen to be mothers, for example, end quote. So with the pandemic and many of us working from home, the ability to hide our caretaking functions is lessened, and or perhaps we're doing more caretaking. So it's worthwhile to note that there are in fact places and laws that pre-pandemic recognize this reality. We've seen the term familial status as a protected category in jurisdictions outside Kansas and Missouri. There are two listed here. Closer to home, in Kansas City, Missouri, that city prohibits discrimination on the basis of familial status in its housing code and its other public accommodation laws. And pre-pandemic, there are jurisdictions across the country that provide time off for parent employees to attend school-related activities. In Louisiana, an employer may grant an employee 16 hours off to attend or observe or participate in conferences or classroom activities that cannot reasonably be scheduled during the non-work hours of the employee. In Minnesota, employers must grant an employee 16 hours off to attend school-related events that cannot be scheduled during non-work hours. In North Carolina, the General Assembly has kind of gone a step further. They say, quote, it is the belief of the General Assembly that parent involvement is an essential component of school success and positive student outcomes. Therefore, employers shall grant 4 hours per year of leave to any employee who's a parent so that the employees may attend or otherwise be involved at that child's school. So very briefly, as HR folks know, there are practical workplace problems that can have legal consequences. Specifically, in terms of performance management, I want to reiterate that employers can set performance expectations and employees should meet those expectations. It's certainly reasonable to expect that expectations are met. But things are a little different right now. Some people are working at home, some people are rotating when they come in, and it's really worth thinking through what makes sense at this moment in time. And Julianne, if you could hear me over there, managers too may need to consider adapting their expectations. In many ways, this pandemic has pulled back the curtain, and we see employees at all levels of organizations who have children or caretaking responsibilities. And we're getting asked by clients a lot, what, if anything, should I be doing differently to manage performance? The answer? Flexibility. Flexibility is key to retaining talent. Flexibility is key to employee morale, to maintaining a diverse and inclusive workforce, and to minimizing risk. So the last topic I want to talk to you about today relates to pregnant employees. The CDC has stated that pregnant people may be at an increased risk for severe illness from COVID-19 as compared to non-pregnant people. That's the public health guidance. On top of that, we have employment law, which prohibits discrimination based on pregnancy. And like caregivers, stereotyping is also impermissible. We cannot assume, even if high risk, that pregnant women will want to be working from home. Now, the FMLA covers leave for birth and bonding with newborns. And did you know that in Kansas, there's actually job-protected leave for delivering mothers, regardless of whether an employer is covered by the FMLA? Pregnancy itself is not a disability, but there are two contexts in which accommodations may be requested. The first is under the Pregnancy Discrimination Act, which requires employers to treat employees who are unable to work due to pregnancy just the same as it would treat an employee who was unable to work due to a temporary disability. The second context in which disability, or rather in which accommodations may arise, is with a pregnancy-related complication, like preeclampsia. And that's the same kind of reasonable accommodation that you are all already familiar with. Well, that's about all I have for you folks here today. I think it's about time to say bye-bye.
Bye-bye.
You say bye-bye?
Bye-bye.
All right, back to you, Julianne.
Thanks, Jenna. To wrap up our section, we leave you with some best practices. First, don't make assumptions based on an employee's ability or inability to work. Second, make sure your policies are updated and current to ensure a mutual understanding of the rules, specifically non-discrimination policies, reasonable accommodation policies, leave, telework, and complaint procedures. In addition, make sure your job descriptions are current. I try not to miss an opportunity to emphasize the importance of current job descriptions. They identify the qualifications for hiring, set the basis for compensation, help with performance management, and in the COVID environment in particular, identify the essential job functions, including those that must be done at work and those that can be done at home. In addition, remain flexible and keep the lines of communication open. Communication in any relationship is important, and the employment relationship is no different. Finally, this is a stressful time for everyone. Consider the resources available and remind employees about wellness and EAP programs that are available to help them. And now I'll turn it over to Brian.
Thank you, Julianne. As Julianne mentioned, my name is Brian Hendricks, and I'm a partner here in Husch Blackwell's Washington, D.C. office. I've been practicing occupational safety and health for a little over 20 years now. And of course, like for everyone else, this year has been a bit different. Fortunately, the difference is related to the type of hazards that we're dealing with, the context, the issues. But the advice that I've been giving to clients hasn't changed all that much. And so what I want to walk you through now very quickly are some keys to OSHA enforcement or OSHA compliance during this pandemic. Now, there are two narratives that have arisen that it may have confused employers a bit about OSHA and what OSHA is doing. One of which says that OSHA is not on the job, that OSHA doesn't have the tools or the resources, it doesn't have the regulations that it would need to protect workers from COVID-19. This other narrative, and the narrative that really aligns with what we're seeing in the field, the reality here, is that OSHA very much does have several specific standards that it can and has used to protect workers from COVID-19. And it also is very much on the job. Since March, OSHA has processed more than 40,000 hazard complaints and referrals related to COVID-19. Now, the last number that I have, as of late May, beginning of June, OSHA had received more than 1,300 whistleblower complaints related to COVID-19. And in response to those many thousands, the 40,000 hazard complaints, OSHA has opened more than 1,000 inspections. 602 of those inspections have involved fatalities or hospitalizations of employees. Now, these are all COVID-19 related. OSHA is also doing what OSHA normally does and is responding to other types of safety and health complaints. And what this means is that we're seeing, and the nature of the pandemic is such that a lot of employers in industries that wouldn't normally see OSHA suddenly are. Because COVID-19 applies or affects all of us in all workplaces, whether it be an office or a manufacturing facility. So what we're seeing is employers who wouldn't normally have need to deal with OSHA suddenly realizing that they do, in fact, have to or have an interest or a need to understand what it is that OSHA expects of them. Now, these are the essential industries, the top industries where OSHA has been spending its time, the top 10 as it were. And you can see, for example, automotive repair, that's not normally where we would see OSHA spending its time or focusing its efforts. Same with grocery stores. Grocery store is the third on this list. Now, in terms of OSHA's tools, the regulations that most directly apply to this type of hazard, OSHA's personal protective equipment standard, PPE, or personal protective equipment, those are gloves and masks, specific types of masks, specific types of respirators, face shields. Face shield is a form of PPE. Certain types of clothing are personal protective equipment. I will say, because this is a question that we receive quite a lot, cloth masks do not count as personal protective equipment. So neither OSHA's personal protective equipment standard or OSHA's respiratory protection standard would apply to the cloth masks. But to respirators, the N95 masks that you may have heard about, both of these standards would apply. Now, final tool that OSHA has is perhaps the most applicable. This is OSHA's General Duty Clause. This is the catch-all provision of the Occupational Safety and Health Act that basically requires employers to provide a workplace, place of employment, which is free from recognized hazards that are causing or likely to cause a serious injury. So the hazard needs to be recognized by the industry. So we have to know what it is, and it has to be of a very serious nature. There are questions about whether or not COVID will meet that likely to cause death or serious physical harm. That's not settled, a settled area of law. OSHA is very confident that it does, and for compliance purposes, what we've been advising clients is that they should assume that General Duty Clause will apply. Now, what OSHA does with that is OSHA says you need to follow the CDC and OSHA's own COVID-19 related guidance. If you follow that guidance, you're doing what you can to keep your workplace free from this recognized hazard of COVID-19. Now, that leads us to what are the keys of compliance? These are the things that, and there are just a few things here that you need to do in order to comply with OSHA's both regulations and the General Duty Clause. First, develop a plan. Develop and implement a written COVID-19 plan. This is a risk assessment. It doesn't have to be performed by someone who is a professional in risk assessments. You don't need to be a healthcare professional to perform an assessment like this. You simply need to look at the guidance and implement or develop and implement a written plan that follows along with the guidance that OSHA is providing employers and the CDC is providing. The plan should first be specific to your workplace. Second, it needs to identify all the areas and tasks that are going to bring folks into contact with COVID-19. And finally, you need to take control measures to eliminate or reduce such exposures. What that means is, what can you do to ensure that your employees don't have to spend much time in close contact with one another, that they are wearing the cloth masks or appropriate protective equipment, other appropriate protective equipment. Those types of things. Are there physical barriers? Are there common areas that you can eliminate or that you can shut down, barricade off, so that employees aren't congregating with one another in those spaces? Second thing you need to do is train your employees on the plan and enforce it. And finally, you need to address employees' concerns as they arise. When an employee comes to you, you need to, with a concern or a question, you need to answer that. And finally, of course, you need to document all of this. The guidance that you really should start with is guidance, OSHA's guidance on returning to work. It's guidance on preparing workplaces and the guidance for business and employers responding to coronavirus. That's the CDC. These two websites, the CDC and the OSHA website, have a tremendous amount of guidance, including industry-specific guidance. Now, finally, I want to speak real briefly here about whistleblower complaints. Whistleblower complaints related to COVID-19 are very much up. We're dealing with quite a lot of them. And a whistleblower complaint in the OSHA context, if you think of it in the same way that you would think of any other employee complaint related to employment, and handle it in that way, you'll be in
Thanks, Brian. As Brian mentioned, my name's Courtney Steelman, and I'm in our Kansas City office practicing labor and employment. Today, I'm going to briefly be talking about reporting, testing, and waivers. However, I'm not going to be able to cover all the material in the slides, so I encourage you to go back at the end of today's presentation and take a look, and also take a look at the related links down below. As many people know, COVID-19 has presented new issues and new questions to employers over these past 6 months. Some of these issues and questions have been addressed by the regulations and other guidance. However, many have not. Today, we're going to look at those reporting requirements, testing protocol, and workplace waivers, and also the best practices associated with those. When you're looking at reporting requirements, there's a two-part consideration. First, looking at if COVID-19 is a recordable illness per OSHA, and also looking at the medical record keeping from employer-mandated testing and health screenings. First, as most of us know, OSHA reportable illnesses are those that are serious work injuries and illnesses, and those are records that must be maintained at the work site for 5 years. But is COVID-19 reportable per OSHA guidelines? The answer is yes. In a memo on May 19th, which was effective May 26th, OSHA provided some time-limited guidance mentioning that COVID-19 was a reportable illness if those 3 prongs are met. Now, OSHA has also provided Forms 300 and 300A for employers to use to record their reportable injuries. Those forms can be found in the links as well. Secondly, we need to look at OSHA's medical record keeping requirements. OSHA has noted that certain records related to medical or health screening may qualify as medical records under their Access to Employee Exposure Medical Records standard. This means you would need to keep the records during the duration of the worker's employment plus 30 years. So do health screenings, temperature checks, symptom trackers all qualify as medical records? Well, it depends. First, there's some things that you need to consider before implementing this health screening at your workplace. Are you going to use internal employees? Do you have medical staff? Are you training employees? Are you using a third-party company? Is there a union that you need to look at the collective bargaining agreement with? Are you going to do this daily, weekly, self-monitoring? OSHA's provided some return to work guidance that has noted that employers do not need to make a record of temperatures when they screen workers, but can acknowledge that temperature reading in real time. However, if those temperatures are being taken or made or maintained by a physician, a nurse, or other healthcare personnel or technician, then it may qualify as a medical record. And what about symptom tracking? Also, who's considered other healthcare personnel and technician? Is it the role that you have, or is it your actual title? Now, while there's not guidance on that quite yet, we do know that there's some pros and cons of screening. Now, if there's a burden of record keeping that should be considered, you also should consider the cost of hiring personnel. You need to consider the potential exposure liability of those employees that you're using to implement the screening, but also weighing that against the future claims liability that might come about from a COVID-19 illness. As many of you know, health screening of employees is okay, but you do need to make sure that you're protecting those personnel that are administering the screening. Also, the CDC has noted that employers should not require a sick employee to provide a negative test or a doctor's note before returning, but instead following the ending home isolation guidance. Further, the CDC has also not recommended employers use antibody tests to determine which employees can work. So, does an employer have an obligation to report those cases to their local health department? Again, it depends. Currently in most jurisdictions, no. However, this is state and local specific. Now, briefly, I want to talk about waivers. Employee waivers, volunteer waivers, customer waivers. Are they applicable? Well, some things you need to keep in mind is that each jurisdiction has different requirements about signatures, assumption of risk, notice, and specific language. In Missouri, you do need a signature for a valid waiver. Waivers must only be against negligence and not intentional torts, and it's not technically against public policy, but that language will be strictly construed against the employer. In Kansas, waivers should also be signed, and they're valid unless there is that disparity in bargaining power, and the release does not need to contain express language. So what does that mean to these different types of waivers? Employee waivers are particularly limited, and they are typically disfavored due to that unequal bargaining power. Also, a waiver would not replace the OSHA requirements to keep your employees safe. However, volunteer and customer waivers may be generally applicable, and it's very similar to a simple assumption of risk understanding. It's important, though, to consider the pros and cons of both. And lastly, COVID-19 liability protection has been a hot topic in local and also statewide legislatures. Kansas has passed an act that protects civil liability from certain groups. Missouri has yet to do so, but there have been calls from legislators to the governor for a special session. Thank you. Take a look back at the other slides, and back to you, Paul.
Thanks, Courtney. First, my apologies. A couple of the technical difficulties in going from speaker to speaker. We had, I think, close to 900 registrants today, and that may affect our ability to be as nimble as we'd like to be with the technology. So thanks for bearing with us on that. Next, we're going to go to what is an unfortunate reality of the workplace. We're going to talk a little bit about reductions in force. Hopefully, many or most of you haven't had to go through this, but in this pandemic time, and with everything that's happened in the last 6 months, we know some of you had, and some of you may still be considering it. So I'm going to take this over to Brian Zickafoos, who is a guy who's so nice we had him speak twice. And Brian, to you.
Thank you, Paul. This is Brian Zickafoos again, and I'm here to talk to you this time about reductions in force and considerations with your RIFs. I have almost the impossible task of talking about this in about 5 to 6 minutes. So what I would like to do is kind of hit the high points and then provide my slides to you in PDF form or whatever form it is, so that you can use that as a reference for an upcoming RIF should that happen in your company. So when looking at a RIF initially, there are two most important factors in my mind, which are time and planning. You have to have sufficient time, and you really should do sufficient planning. Without either of those two things, it ends up being rushed and could expose you to additional liability. So please take the time and have a plan when you go about initiating a RIF. Identify your goals and objectives. What do you want to do? What's your plan? What are your goals? Do you want to reduce payroll expenses? Do you have specific monetary goals that you need to hit? A certain amount provided by the finance folks, or a percentage headcount reduction? We've got to cut 10% of our headcount. Is it going to be widespread? Or are you going to focus on certain departments or locations, depending on profitability or other factors? And are your needs permanent or temporary? When you're talking about permanent, you're generally talking about involuntary reductions in force and voluntary reductions in force. And there are some differences here that I think are important. When you're looking at an involuntary reduction, they're more definitive. You have more control as the employer. You decide what your goals are, who unfortunately has to go, and you go about implementing that. It is also the potentially highest risk option because you are severing employment and it's your decision. With regard to voluntary RIFs, you have, as the employer, you identify your group of eligible employees, and then they get to decide if they want to take advantage of the plan or not. And again, it absolutely has to be 100% purely voluntary, otherwise it will not pass muster. And it gives the employees all the control. It also takes a bit longer because you have an opt-in period and a consideration period that will likely take months at least. You have some temporary types of reductions as well: furloughs, targeted or broad salary reductions, reducing hours, pay freezes. You can implement these as well. They are less severe than a reduction in force. And these can also be sequential. You can start with a furlough or a hour reduction or a pay reduction or a voluntary RIF. And if you don't see the financial targets met that you need, if that's what is in fact driving you finances, then you could follow up with an involuntary reduction. So these are not mutually exclusive. Everything we're talking about today is assuming that employees don't have rights under an employee handbook, employment agreement, or collective bargaining agreement. If you do have any one of those things that affects your employees or your ability to affect the employment of your employees, that needs to be taken into consideration as well. And I would also make sure that you involve legal counsel, whether it be internal or external, to help maintain the privilege of your decision-making process as you go through the various evolutions of your thought process. Once you have your initial plan in place, make sure you identify your decision makers and set a timetable. Again, I think it's going to be weeks to months generally, depending upon how sophisticated or widespread your reduction is, and discuss whether or not you're going to provide severance. We suggest you do so that you can obtain a release and waiver from your departing employees. What that amount is discretionary, 1 or 2 weeks a year, standard amount. It's really up to you. Now, this slide is very meaty. There's an awful lot here. Once you've identified or kind of narrowed down your plan, you need to identify your selection criteria, whether that's going to be performance, job knowledge, skills, job type, departments in particular, whatever it is. Generally, the more objective, the better. And then you need to discuss these criteria with the decision maker so that they know what criteria need to be used so you can have consistency. Then you develop a preliminary list of employees for the reduction and challenge that list from a discrimination standpoint. Look at all the protected categories, disparate impact, which is facially neutral statistical discrimination, and disparate treatment, which is intentional discrimination. Look at those comparable or similar positions where people could argue that a protected category was really at issue. And also look at protected activities like complaints of discrimination, whistleblowing, like we talked about before, FMLA leave, and the like. And then you finalize your list of employees that will be RIF'd. Another timing consideration is the WARN Act. This may or may not apply to you if you're going to RIF. If you have more than 100 employees and you're going to RIF at least 50 employees, you may be eligible. You can see there are a number of different criteria here, and there are also other nuances to this. So just know that the WARN Act is out there. And then what I consider to be a pretty important part of this, which is waiving age claims, the Age Discrimination Employment Act and the Older Workers Benefit Protection Act, or OWBPA. There are these requirements here that you can see. And the last requirement is the one that generally takes the most time. You need to identify your decisional unit, identify those criteria that are being used for separation, identify who is being considered for the reduction, and the job positions or positions of the people that are selected and are not ultimately selected. And then I think I'm out of time here, but make sure that you have a termination meeting where people are educated, ready to go, scripted, and then that you have clean communication with the remaining workforce so they know what's going on. And now I'm going to pass it to Christine Fabian to talk about foreign national considerations.
Thanks, Brian. I just wanted to give a quick public service announcement. If you are an employer who's thinking about a RIF, a furlough, putting employees into non-productive status generally, consider whether or not you have foreign nationals that are going to be impacted. And I say this because, you know, a lot of these visas kind of hinge on the hours worked by a particular employee. So for example, an H-1B employee, if you're an employer of an H-1B employee, you have taken and made certain attestations that you will continue to pay the H-1B employee for the duration of their visa, regardless of whether or not they're logging hours. And you've attested to pay the prevailing wage, so their salary consistently. Also with H-1B employees, in the event that you want to terminate them, right? So if you're planning on having a big furlough, but you decide, we can't continue to pay this H-1B worker for the duration of the furlough, and so we're going to terminate them. In that case, also keep in mind that we have to, as employers, offer them a one-way ticket back home. So each different visa category has different things to consider in the event that there is a RIF or a furlough, or you're otherwise terminating or placing a foreign national employee into non-productive status. And just make sure that you're having those conversations with your immigration attorney. And with that, I'm going to hand it back off to Brian to close us off.
Thank you very much, Christine. We appreciate the insight. And Paul, I will turn it back over to you.
Thanks, Brian and Christine. That brings us to our second poll question. Again, it'll come up on your screen. Get your mouse ready. Has or is your company conducted a reduction in force or furlough in the last 6 months? Considering conducting reduction in force in the next 6 months? Neither of the above or both of the above? Plug in your answers and submit, and we'll have the numbers for you in a minute. All right, numbers are in. Just under 30% have conducted one. Just under 5% are considering one. 55+% neither, and 10 or 11% both. Again, thank you for taking the time and for helping us benchmark what's going on with our clients at this time. That takes us to the next topic, which I'll bet each of us wishes we weren't having to deal with right now. Political speech and election issues. We are about 5 weeks away from a pretty interesting event in our country, the next election. And as it usually does at this time, political speech is going to heat up, whether it's whether it's on the internet, whether it's at work. We'll see. But we have to talk about it here. Tim Hilton is going to head up our next group, and Tim, I send it your way.
Hi, everybody. Thanks, Paul. I appreciate that. And thank you all very much for joining us today. And we're excited to be able to virtually connect with you during these set of seminars as much as possible during this time. Today, my colleagues, Tyler Hibbler and Jessica Barranco and I'm Tim Hilton, are going to be talking with you about some issues related to the political climate and hot button issues that may come up that may bleed into the workforce at any point in time. Of course, those issues can happen at any time, but during an election year and during the increasingly seemingly contentious state of public discourse, this is an issue that a lot of employers are wanting to re-review. And in addition to the normal political cycle, obviously the pandemic and the resurgence of protests and actions related to social justice and racial justice are added factors that employers are going to have to deal with and think about how to handle. So today I'm going to spend a little bit of time talking about what I would term free speech issues in the workplace. We're going to cover some issues related to social media policies as well. Then Tyler and Jessica are going to take over. Jessica is going to cover a little bit about election leave issues as the election is coming up soon and what that means in Missouri and Kansas. And also Tyler's going to cover the kind of hostile work environment harassment aspects that may be important when dealing with these types of issues. So first I'm going to talk about, as I said, free speech. The concept of free speech and it's a free country is very ingrained in us in America as Americans. But as we probably remember from civics class, it's really not true always in the same way in the private workplace as it is compared to the government. The First Amendment does not apply in private employment, but that's not to say that your employees aren't protected in some general way that they might consider to be free speech. Employees are often protected in comments about working conditions by the National Labor Relations Act, even if they are employees who are not unionized or in fact cannot unionize. Everybody has Section 7 rights. And including that may even relate to issues arising out of the dress code and the words that you're allowed to put on an article of clothing. We're going to talk a little bit more about social media in different contexts later, but even a like or a share or a favorite of a protected social media post may be lawfully protected. However, the National Labor Relations Board has recently confirmed in a case arising right here out of the Kansas City area that abusive conduct that is otherwise covered by an employer's policy is not inseparable from protection if the employee is also engaging in something that might be protected activity. So that's you cannot simply engage in a series of abusive comments or profane comments and then add in a protected element at the end of it in order to gain protection. When, for any of you who may be public employers or public entities, the words are a little bit different. The issues are a little bit different as employees do not give up their right of free speech completely when they take on a job in public employment. For many years, the courts looked at a balancing arising out of a case called Pickering between the public concern that is raised by the speech, if there is any, and the balancing of the impact that the speech may have on disrupting the efficiency of the government office. More recently, Supreme Court in the Garcetti case has ruled that when an employee is speaking pursuant to his or her official duties, there is no First Amendment protection. Now, the public employees are still protected a little bit more than you might think, because if they are not speaking pursuant to their official duties, courts often revert back to the old test and looking at balancing the importance of the public concern raised by the speech versus the impact that it may have on the efficiency of the government office. Social media policies have been a big subject of review by the National Labor Relations Board in recent years. And when I say social media policies, I mean policies by which employers are governing what their employees may or may not say on their personal social media pages. These have swung wildly over the last 8 years and will likely continue to do so in the future. As it stands right now, employers can institute a wide range of social media policies, but they should still be very careful when applying those to issues in which when work issues are discussed online, as those Section 7 rights that I mentioned earlier are still in play when an employee is discussing work conditions on social media. Finally, as we've all seen, unfortunately, the issue of masks and face coverings is a pretty contentious topic right now. And many of our clients are instituting policies requiring masks, and many of our clients are subject to government orders requiring masks. We've all seen viral videos, and despite some data suggesting that usage of masks is a lot more popular than you might think, it's unquestionable that they're very controversial. So you may have seen things about the requirement of a mask violating the ADA, that it violates my religion, or that it is a violation of the Constitution or HIPAA. To come kind of addressing those in reverse order, the HIPAA and unconstitutional aspects of things are really not issues that are going to come up for most employers. And if you hear employees addressing those things, it's not going to be a big concern. If someone is raising a concern that a mask requirement violates the ADA or violates their religion, you should look at whether or not the person is making a request for an accommodation. And under the ADA, if the request for an accommodation, if they have a physical condition or a mental condition that prevents them from wearing a mask, you should run through your typical reasonable accommodation process to determine if it would present an undue hardship. And in terms of a religious accommodation, you need to address that using your normal religious accommodation process, and you're likely going to be required to accommodate it unless it presents more than a minimal burden on operations. So those are the things I'm going to cover today. Now I'm going to kick it over to Tyler and Jessica for their portion of the presentation. Thank you very much, everybody.
Thanks, Tim. I'm going to talk about state voting leave laws. In both Missouri and Kansas, an employee is entitled to paid leave on Election Day. In Missouri, an employee is entitled to 3 consecutive hours of paid leave, and in Kansas, an employee is entitled to 2 consecutive hours. What this means is that if an employee's shift starts at 7 a.m. and ends at 7 p.m. and the polls are open for those hours only, an employee in Missouri would be allowed 3 hours off, and an employee in Kansas would be allowed 2 hours off. However, if the polls are open from 7 a.m. to 7 p.m. and the employee doesn't start work until 10 a.m., then the employee is not entitled to paid leave in either state. Moving on, we've seen some concerns with strikes and walkouts as a result of the current social and political climate. Both unionized and non-unionized employers have seen these strikes and walkouts. The National Labor Relations Act allows employees, even if non-unionized, to engage in this type of protected concerted activity. Employees could walk off the job and the NLRA will protect them. But if an employee chooses to sit down or stop working while remaining on the business, then the employee is not protected by the NLRA. Regardless of whether the employee is protected in their actions, the employer must consider all perspectives when responding to these types of concerns. This includes not only the employer's perspective, but also the employees and the public's. Any inaction or action could cause backlash or concerns from the public and employees. The employer should consider their internal policies whenever making a decision on how they want to act in response to something like a strike or a walkout. Going to you, Tyler.
Great, thanks, Jessica. I'm going to transition the focus a little bit and discuss political conflicts in the workplace and when political discussions or discourse can translate to harassment. I don't think it's a surprise to anyone that in the current environment, there is a risk of political expression or political speech permeating into the workplace and either hurting the feelings or making others feel isolated. While as employers, we want to encourage a diversity of thought, it's also important that we are cognizant and cautious of political expression becoming workplace harassment. Now, what laws are at issue here? Title VII, the ADA, and the ADEA, while these laws ban discrimination on various protected classes, they do not ban discrimination on the basis of speech, even political speech. This includes direct application to political speech in the workplace. However, political discussion can devolve into harassment or discrimination claims, and certain types of political speech may constitute protected activity, as indicated by Jessica and by Tim previously. So when does speech translate to harassment? Political speech at work can cross the line into harassment if it singles an employee out according to a protected classification under a variety of laws. This includes Title VII, the ADA, the ADEA, and it also includes various state laws, such as Missouri employment laws, as well as the Kansas Act Against Discrimination. Typically, you see this arise in employee-to-employee interactions. Employees are sitting around the workplace, discussing politics, and somebody makes a statement which may single out an employee or constitute discrimination or harassment based upon a protected classification. It also occurs with external interactions, and this is something that employers also need to be aware of. Employees often interact with customers and vendors in a variety of circumstances and a variety of situations. Sometimes those customers and vendors are emboldened to express political opinions, which can have an effect of harassing or isolating your employee. As an employer, if you're aware of that, you may need to take action. Ultimately, it's difficult to assess when political speech may translate into harassment. And context is often important. We live in a society today that is based heavily upon identity politics. And unfortunately, for many people, that is translated to an us versus them mentality, or a good versus evil mentality, where a political viewpoint is much more than supporting a candidate or supporting an issue, but is instead supporting a value system. And it's important that employers are aware of how employees communicate to each other regarding these diverse issues and the diverse opinions, and also how they demonstrate respect for each other within the workplace. Another issue to consider is social media. Tim spoke about this earlier, but there is a great risk for social media to permeate back into the workplace. People feel much more emboldened to discuss their opinions on social media and are often friends with coworkers. As an employer, you do have the ability to regulate and even discipline employees when expressing harassing or discriminating opinions on social media, as long as they are not covered by various legal considerations such as the NLRA, state law considerations which protect political speech outside of the workplace, and as long as it's being provided in a uniform application or manner. So what's the advice for employers? How do we handle these issues? Our recommendations are first and foremost, be proactive. Consult with legal counsel to implement a well-crafted policy which addresses political activity and speech in the workplace. And then communicate that policy to your employees through training sessions on showing respect for coworkers and establishing clearly defined expectations for such interactions. And management needs to lead from the top. Management needs to set the standard for respectful interactions in the workplace. Management needs to set the standard for adhering to policies regarding political activity and speech in the workplace. And then the employers need to follow up. And now's a great time to do this. We're sitting about a month out from an election, a significant election. Debates are beginning to start up. We are in the heart of campaigning season. And so periodically remind employees that the company will not tolerate discrimination, harassment, or retaliation, even if speech originated as political speech. And then finally, promptly and neutrally address any disruptive or unlawful political communications that fall outside of the scope of the NLRA or any other laws which may protect such conduct. These are all difficult things to navigate. If you have questions or concerns, you can feel free to reach out to one of our attorneys here at Husch Blackwell. Otherwise, we appreciate your time. And now back to Paul.
Thanks, guys. Appreciate it. For our next and last poll question, we're going to ask you who you're going to vote for in November. No, we're not really going to do that. Our last poll question is, my workplace has a written policy that addresses political speech and activity. Agree, disagree, or not sure? All right, the results are in. It looks like 55% have a policy, 24% don't, and 20% aren't sure. Again, good benchmarking. I appreciate that. Let us know if we can be of any help if you need a policy. That takes us to our final segment of the day, which is immigration and OFCCP issues. I told you earlier we look at our surveys, and if there's one thing we see in our surveys over and over, it's that folks want more Christine Faban time. And so we give the people what they want. So I'm going to turn it over to Christine Faban and Molly Kurt, who are going to close us out on this. Christine?
Thanks, Paul. And thank you all for being here. I know that this is very different than last year, but we're excited to be in the same space as you. So anyway, my name's Christine Faban. I am one of the immigration attorneys in the Kansas City office at Husch Blackwell. And I'm hoping to just kind of give you a quick run through of what we've been seeing in the immigration world since COVID started, really. The three big things that I'm hoping we can talk about today are foreign national employees and what it looks like for them to be working from home, international travel and the different restrictions that we've seen with international travel and COVID-19, and then work from home for foreign nationals who are abroad. So let's hop into it. One of the biggest topics, and I think one of the ways I've spent most of the last 3 months is talking to employers about foreign national employees who are working from home. Something to keep in mind is that foreign national employees have a very different set of standards and regulations that apply their working relationship with their employers. So, for example, the H-1B visa is a visa that's employer-sponsored, that's tied to the worksite location of the employee. So in the event that you have H-1B workers and you've also taken the stance as a company or an organization that you're going to be moving to a work from home method, you should contact an immigration attorney to kind of discuss what that looks like. Specifically, we're really focused and kind of more worried about foreign national workers who are working outside of the metropolitan statistical area. In the event that they are working outside of the metropolitan statistical area while they're working from home, then it's likely that an H-1B will need to be, their H-1B will need to be amended. And that also the labor condition application, which governs the wage for that H-1B employer, will need to be resubmitted, and possibly a higher wage will come back from the U.S. Department of Labor. The other visa types, that we work with, primarily Ls and TNs and Es, the regulations don't really care as much about the specific worksite, but I will kind of put in a plug that with F1 OPT students, if you're an employer that has F1 OPT or CPT students as employees, you should definitely encourage them to tell their university and disclose to their university that they're working from home in the event that you move to a more work from home methodology for your company. So, in the interest of time, we probably won't be able to run through examples, but if you are someone that has been with us for these seminars in the past, you will know that I usually present with Kelly Mylink, who is another one of the immigration attorneys in our office. Kelly called me last night to tell me she was going into labor. So that is why she is not here with us today. And this is Ella Catherine Mylink. She came in at, I believe, 7 pounds and 11 ounces, and I cannot wait to meet her. And hopefully next year we'll have an updated photo of her as a 1-year-old and maybe crawling, walking around. So the next topic that I wanted to briefly touch on was international travel. Is international travel, as I'm sure many of you have seen in the news, COVID-19 has really impacted international travel, especially for our foreign national workers. There are a host of countries, many of which are in Europe, and then also China, Iran, Brazil, that are restricted. And that means that if you are a foreign national and you've spent time in any of those countries, you are not allowed to enter the U.S. Unless you quarantine for 14 days in another country. So this has provided a host of issues for us. And then on top of that, there was an executive order that went into place, I think last month, that basically suspends the issuance of certain types of visas. And a lot of the visas that we work the most frequently with, so H-1Bs, L-1s, F-1s. So that's something else to keep in mind. If you have foreign nationals that are trying to process abroad, you will likely run into issues. And then the third thing, if you're lucky enough to not have a foreign national that's not affected by the travel ban and is in a visa category that's not affected by the suspension on visa issuance, and they're in a country where, you know, they can just make a consulate appointment. What we've seen is that most of the consulates are still closed, or only issuing appointments or giving out appointments on a very limited basis, usually when there's an emergency involved. If you do have someone that is stuck abroad, feel free to reach out to us. We've come up with some pretty creative solutions in getting people into the U.S. So it's possible, although it's a bit of a fight. So finally, just wanted to touch base on working from home abroad. This has been a question that's come up a lot in the past few months. And what this usually looks like is that an employer will have a foreign national employee that's either one, stuck abroad because all the consulates are closed, or they're from a country where there's a travel ban. Or two, the foreign national just wants to go home and work from their home country. In the situation that you have a foreign national who's wanting to work from home abroad, keep in mind that there are certain things that you should consider, including, the immigration laws of that particular country, the tax laws and how they affect payroll for you, and then also the country-specific employment laws that come up. So again, in the event that you do have a foreign national that's wanting to work from home abroad, feel free to reach out to us or your immigration lawyer or attorneys, and they can kind of walk you through the considerations for that. So with all that said, call us. We're here. We are happy to answer and field whatever questions you might have. We know it's definitely a crazy time, and it's been a hard time for a lot of our foreign national employees and foreign national sponsoring employers. But with that, stay tuned and posted. We're constantly putting stuff on our blog and website. And fingers crossed, things shake out a bit better for our employees. So anyway, thank you for your time. And I am going to hand it off to Molly Kurt, who's going to be talking to us about the OFCCP. Thanks.
Thank you, Christine. I'm Molly Kurt. It's a pleasure to be with you today and to speak about one of my favorite topics, the OFCCP. For those of you who may be new to the subject, OFCCP stands for the Office of Federal Contract Compliance Programs. It's an agency within the U.S. Department of Labor, and it has jurisdiction over employers who are also federal contractors or subcontractors. In most cases, the contract has to be at least $10,000 for these obligations to kick in. OFCCP's rules and regs require equal employment and affirmative action. They are limited to only 4 protected classes: sex, race or ethnicity, protected veterans, and individuals with disabilities. Perhaps the biggest surprise to me this year was the news that OFCCP Director Craig Lean is moving on. In February, he was nominated to become the Inspector General of the Office of Personnel Management, which is the federal government's internal HR department. It was disappointing because Lean has been extremely effective as the director of OFCCP. His nomination has been approved, but no date for the transition has been announced, nor has a replacement been named. Lean leaves a legacy of transforming OFCCP into the most practical, reasonable version of itself in decades. The change in leadership at OFCCP dovetails with the election season. Historically, OFCCP's agenda has swung dramatically, depending on who occupies the White House. The agenda can also reflect the director's personal style and priorities, as in the case of Lean, who emphasized transparency and efficiency. Whether or not there's a new director named to succeed Lean before January, if there is a new president, he would name his own director. I'm not good at predictions, so the best I can say is stay tuned. There have been many interesting developments in the last year or so at OFCCP. There really isn't an overarching theme uniting them all, so I'll run through what I've labeled a medley of items. To begin, a topic that may impact some of you very directly, OFCCP just published the CECL list. CECL stands for Corporate Scheduling Announcement List. It's a newer method that OFCCP uses to give a heads up to companies that they may be audited in the coming year. 2 separate lists were published, one for construction and one for supply and service contractors. So this is how the timing works. The list was published September 11. OFCCP will begin sending out audit notices in 45 days, or on or about October 26. The goal of the CECL is to avoid lengthy extensions of time that slow down the audit process. OFCCP has announced that it will not grant extensions of time to respond to the audit, except for one 30-day extension for good reason. A silver lining here is that OFCCP has never had the resources to audit all the contractors on the CECL list, and it will expire in a year. So if you're on the list and you didn't receive an audit notice, your name goes back in the hat for the next round. There isn't any carryover. Next, and I think this is big news, OFCCP has been talking about a verification or certification process for years. Finally, this summer, they announced a proposed rule laying out a certification process. To date, there's been no way to verify whether contractors are keeping up with their annual compliance responsibilities. It was an honor system of sorts. The proposed rule will require contractors to certify in one of 3 categories through an electronic portal. It's essentially yes, no, or we're a new contractor and we haven't put our first AEP in place yet. On balance, it's a very reasonable proposal and should be a short exercise. Earlier speculation included the option of submitting all or part of your AAP, and that would have been far more time-consuming. A couple of notes about the VETS 4212 and the EEO1 form. The VETS 4212 is still due on the traditional due date of September 30th. If this applies to you, it's not too late. A link to the instructions and filing process is here. We know historically that the VETS office has kept the website open for several weeks after the deadline. So if you're behind this year, give it a try even after September 30th. We know now that the EEO-1 form, also traditionally due September 30th, will not be due until sometime in 2021. The due dates have been a moving target in recent years, and the good news is that it's delayed until sometime in 2021, perhaps March 31st. The bad news is that it'll be 2 years worth of reporting for 2019 and 2020. Thankfully, the ugly and burdensome component 2, which reported contractor pay data, has been canceled for good. For those of you in healthcare, there's more good news. A lively debate and legal struggle has persisted for several years at OFCCP over the status of hospitals and other healthcare organizations whose only connection to the federal government was the receipt of TRICARE reimbursements. TRICARE is the federal government's health insurance program for members of the military and their dependents. The new rule declares that OFCCP does not have jurisdiction over hospitals if they are TRICARE beneficiaries. It's a big relief and represents a significant concession on the part of OFCCP. A couple of technical assistance guides out this year, a brand new one for higher education, and it comes with it the big news that student workers may be omitted from affirmative action plans, both on the goal setting side and the applicant hire record keeping side. That's a significant concession to universities because of the high volume of workers in those categories. A new technical assistance guide for construction was long overdue and is now available on OFCCP's website. It incorporates some recent changes to the regulations for veterans and individuals with disabilities. It's very user-friendly and gives you a template for the 16 steps that construction contractors are required to undertake. And nearing the end here, OFCCP addressed the current topic of non-binary employees in an FAQ on the agency's website, August 31st of 2020. As it says here, the contractor may exclude the individual's data from the gender-based analyses in the affirmative action plan, but must still count that employee in the overall AEP numbers. That's all I have today. I hope this has been a helpful summary of a rich and productive year at OFCCP. Thank you, and back to you, Paul.
Thanks, Molly. Thank you all for joining us. That's the close of our substantive presentations today. A couple of things before you go. One, we've had quite a few written questions submitted. Hopefully most of you have had those answered. If they haven't been, we will follow up after this and get your questions answered. And if there's been any problem, please feel free to reach out to your HB contact. And second, remember, if you need CLE credit, particularly Kansas credit, you need to fill out the survey. That's at the CEU icon at the bottom of your screen. Two reasons: one, to get the credit. Two, we really do look at those surveys, not only for your constructive tips on our presentation skills, but also about future topics that you may want to see at future presentations. Speaking of future presentations, we invite you to register and join us next week, October 6th, for the next installment of our Labor and Employment webinar series. So in the meantime, thanks again for joining us and have a great rest of your day.